Well,
So,
I'm sorry, finish, please.
no, thank you.
Well, I mean, following up on this point, I mean, your big policy point is chill. And your point that the lawyer would have to advise the client, I'm not sure if this is going to be privileged, but isn't that the case already? I mean, you don't know whether you're going to be sued on a state claim or a federal claim. And so you might be in a state that, like most states, doesn't follow the primary purpose test. And so that conversation, you could wind up in a situation where that conversation is privileged maybe in one jurisdiction, but not another, if you win.
It's certainly theoretically possible you could have a situation where you have a different rule under state and federal law, and that certainly could happen. I don't think that's a reason to not try to come up with the best and most operable and predictable rule.
But why wouldn't that chill the communication? Because it's not going to be privileged, say, if someone asserts a state law claim against the client.
I'd say that most of the states, and certainly true of the states that the government cites in its brief, when you look at their case law, they may say primary predominant, but then they focus in on, is there a legal purpose or not? So that is, when they apply it, they're applying it the way we say it ought to be applied, which is you go back to the Wigmore test. You ask the basic questions. Are you talking to a lawyer who's acting as a lawyer? Are you communicating for the purpose of legal advice? And if you can meet those thresholds in a legitimate way, it's not pretextual, then you get the privilege. And that is, I'd submit, the way most of the states have actually been applying it.